Now, getting to the tail end of 2024, and information able to just say a Ghanaian, or play integral part in the former Mahama's administration from 2014 to 2016, getting into 2017. His Excellency Nana Akufo-Addo, in fact, able take over the hands of affairs. America by Ensa Akam. Now, Omukwachi no ewo United Kingdom abrochimemu through an Interpol diffusion notice. That is on the 3rd of November 2022. And on my extradited no to America to face the law over the Eastern District of New York. Now, according to America by Omo Tracy Papai for close to 4 years, who said he is engaging in the Omofano say money laundering through the U.S. financial system and after bribery and corruption. Yeah, it's a bribe no, bribing Ghanaian government officials to secure a power plant deal by serving as an intermediary for a Turkish power giant. Now, Yewra Ashanti Media at a point in time, now Oye Tama Oil Refinery Chief Executive Officer. Now, between the period of 2014 to 2016, getting into 2017, or play an active role, yeah, no, an intermediary, a brother Ghana buying. Sabrina Dunsoni Jinasopano, any Turkish energy giants, B.A. Dinkomo, say, Omumrano Messi power plant, and for more. Now, contract no, and Humkomodie, and America buying the money, we will much more. To say, over hundreds of thousands of dollars were paid as bribes for the company to secure the contract. And the payment of these bribes went through the U.S. financial system. Your matrake who say, Nyoma ekoso no, in fact, na ego. Now, U.S. mpanimfo na eboaye na yechi Yewra Ashanti Media na almost effective ni extradition from the United Kingdom to the United States. Brown Peace, United States Attorney for the Eastern District of New York, Nicole M. Agentieri, Principal Deputy Assistant Attorney General, was head of Criminal Division, and after Christy M. Curtis, Acting Assistant Director in charge, the Federal Bureau of Investigations, New York Field Office. Now, we are charges said the boy Yewra Ashanti Media bribing Ghanaian government officials to secure a lucrative development contract, relying on the U.S. banking system to execute his scheme. For over 3 years, spanning from 2014 to the later part of 2017, Ashanti Media, a dual citizen of the US and Ghana, bribed Ghanaian government officials to monopolize a promising business deal and used United States bank accounts to transfer such kickbacks. As set forth in his indictment, Beko conspired with others to bribe Ghanaian government officials in connection with the development and financing of a multi-million-dollar power plant purchase in Ghana. Beko, an executive director in the investment banking division of a subsidiary of a U.S. bank, was responsible for securing and managing a deal between its client, a Turkish energy company, and the Republic of Ghana between 2014 and 2016 for the construction and financing of a power plant in Ghana. Hundreds of thousands of dollars were payment made in furtherance of the bribery scheme, which were laundered through U.S. and foreign bank accounts, including several in Beko's name. Inti sa story nyina no sembe kaya ye de ho sembrem. E just a court case no na ye gya ho akiridi ene ye the latest from U.S. court. Ena ye de ebrem. Now let us say the lawyers Eko file led by lawyer Wilma Cutler, filed motion say U.S. court no and dismiss indictment edan so na afei no so no omo emma motion na yɛmfa suppress materials U.S. FBI SCZ pursuant to such warrant ebi email files ni ade a eno mu tresi di hunu sika hodo a wotu aye any Ghana government officials ahodo a omo Jesus can including members of parliament in order for some Turkish energy giant to secure the building and the operating of the power plant between the period of 2014 and 2016. Now, the memorandum in support of motion begins with the following preliminary statement, making kind because we are called document. Intimate from my enka. Or say, the defendant, Ashanti Media, moves to dismiss indictment as the U.S. government's prosecution suffers from fatal legal deficiencies. Specifically, the indictment, 1, was improperly sealed, and Mr. Beacon's arrest in the United Kingdom was unreasonably delayed, resulting in a circumvention of the statute of limitations and a violation of Mr. Beacon's right to speedy trial. The defendant, Ashanti Media, also seeks the suppression of his personal emails that were obtained pursuant to an unlawful search warrant by the United States Federal Bureau of Investigations. The search warrant improperly relied on conclusory and uncorroborated statements from a confidential source whose credibility and reliability were attested to in the warrant. The warrant was so facially deficient that it should never have been granted or executed. Accordingly, as discussed in detail below, the court should grant the defendant's motion 1 to dismiss the indictment of bribery and corruption and money laundering with prejudice. Additionally, the court should suppress the search warrant for Mr. Beacon's personal emails. Enti lawyer for Ejinamodema Yera Asante Media kuchirima indictment a U.S. abandi ato so for 1 bribery and corruption, for money laundering using U.S. banks ni ade no court enyi sa indictment dem free me so esane say kwan kura no U.S. FBI for far so eje search warrant de behwehwe ne nioma mu edi say indictment to su nyina ato no su nyina according to omo no e unlawful ebien kwan ya search warrant na afa so na yewura Asante Media ko ne personal emails bi a leading wo to the fact say we engage in bribery and corruption to secure that deal no. In fact, eno so amfa kwampa so enti America ban emo eno so ntum. Now, oral argument on the motion was held on August 28, 2025, and in October 30th, 2025, Judge Diane Gujurati held a status conference in which he granted Ashanti Media's request for a hearing with respect to that portion of the motion that seeks dismissal of the indictment of bribery and corruption and money laundering. The hearing of the court occurred on the 25th of November 2025, and the judge ordered post-hearing briefings to be submitted by the 20th of December 2025. In his post-hearing brief, Ashanti Media asserted in pertinent part, at the hearing, the government failed to establish that the indictment was sealed for legitimate prosecutorial reasons. As an initial matter, the government did not offer any testimony or documentary evidence from any of the prosecutors to establish that the indictment was sealed for legitimate prosecutorial reasons. Indeed, the government relied solely on the testimony of its lead case agent, Special Agent Justin McNair, but McNair could not speak to the prosecutor's reasoning for seeking the sealing of the indictment on the preparing for the hearing. He had no role in drafting the language used in the form. He was never consulted by the prosecutors about the accuracy of the statement in the form, and as discussed later, he did not understand certain of the statements in the form to be true, to prove evidence from the prosecutors, not the case agent. Enti wey a legal argument lawyers for Yura Ashanti Media that America applying any airtrain for bribery and corruption and money laundering schemes no omo present here and yenyina so na sa indictment ni gina edana so no yentwam na court and dismiss it. Now yahweh the director of justice the Eastern District Court and so the motion and now also ne argument ya woye ya wode so de kire say sa indictment ni de yetwam a enye yenti ono so de. The defendant's motion to dismiss the indictment for allegedly improper sealing and a violation of his constitutional right to a speedy trial should be denied as meritless, as set forth in the U.S. government's prior filings at oral argument on August 28, 2025 and during the November 25, 2025 evidential hearing, during which the U.S. government called Federal Bureau of Investigation Special Agent Justin McNair and the defendant called his former defense lawyer Carl Lewinson. As detailed at each of those junctures, sealing the indictment and maintaining it under seal was proper, while the defendant remained a fugitive in Ghana and maintained corrupt ties to high-ranking Ghanaian government officials between 2014 and 2016. Further, there was no violation of the defendant's right to a speedy trial because the U.S. government diligently pursued his arrest and extradition domestically and from numerous countries. The defendant suffered no actual prejudice from the delay. And the U.S. Director of Justice at the Eastern Court of Brooklyn, and so edit to just say, and somewhere you are Ashanti Media lawyers say about indictment in Yanokre. Now, a dear cry, a hand say, Ofori FBI agent, ya your friend Justin McNair. Emma Justin McNair be chiri say. A bra na Ashanti Media almost started so more pen on, and you know. During that time, 2014 to 2016, and all broker deals, corrupt deals, you know, and the U.S. tracking that are not open. But now about a fugitive for Ghana, now all maintaining ties with then high-ranking, also corrupt ties with high-ranking Ghanaian government officials in T. Now watching a ye. And at the appropriate time, and when we effecting the arrest and an extradition. Into Omunya Bonibia. Now, on hearing the two motions, U.S. District Judge Diane Jugarati refused to toss the case over Beko's contention that the indictment was improperly sealed and his arrest wrongly delayed, leaving him facing all timely allegations and violations of his Sixth Amendment right to a speedy trial. Dismissal is not warranted on statute of limitations grounds, Judge Gujarati said in a bench ruling. Dismissal is also not warranted on speedy trial grounds. Hence, all charges of indictment against Mr. Beko stands. Enti Judge Diane Gujarati Chilema on to me dismiss case no one on improperly sealed and someone a lawyer to ya. And on to me dismiss case no on arrest wrongly delayed, ya and lawyers refer to. So na on to me dismiss case no on grounds of unwarranted speedy trial. Maybe. All forms of indictment charges, including bribing Ghanaian officials to obtain the deal, including money laundering using U.S. banks, it holds. And with this statement, what it means is that the charges in the indictment needs to be defended by the defendant. And if convicted, Ashanti Media faces a maximum penalty of 20 years in prison for conspiring to commit money laundering and 5 years in prison for each count of violating the foreign FCPA and conspiring to violate the FCPA. The investigation was actively conducted between the period of 2014 and 2016 by the U.S. FBI's International Corruption Unit. The government case is being handled by the Office's Business and Securities Fraud Section, assisted by the United States Attorneys Alexandra Smith, Jessica Weigel, and Tara McGrath. They are all in charge of the prosecution, along with trial attorney Elena Rubin Smith of the Department of Justice's Criminal Division Fraud Section. The Justice Department Office of International Affairs of the United States worked with the government of the United Kingdom, the UK National Central Bureau of Interpol, and US Marshal Service to secure the arrest and the extradition of Mr. Ashanti Media. And for clarity's sake, my indictment no ketwe bi na me fa mi wani kakra na de wo kan wo de abremo comment section. Indictment ni bi ni say April 2015 ehemu say in fact otua bribes edema 5 Ghanaian officials yana ebi wo the presidency, ebi wo the power ministry, ena ebi enso ewo parliament during an all expenses paid trip to Turkey to view equipment for the power plant. Yana bribe no obi aje $5,000. $5,000. Ebi you see August 2015 a bribe of $250,000 was paid to various individuals within Ghana's parliament, and then a bribe of $20,000 was also given to various individuals within Ghana's Ministry of Power. It is stated that a bribe of $800,000 was paid to a high-ranking Ghanaian official that led to the broker of the deal, even without proper parliamentary approval. Almost say they intercepted emails further detailing tens of thousands of dollars in bribes Ashanti Media personally paid to other government officials, all in his name, through US and foreign bank accounts. The way a indictment ni biane inti ama yewra Ashanti Media ejina emra enim. This is a court abo ediato good. The case can continue. Now, in adia emane case here very very interesting ti adia say, because the US amanone asem kan yemfa asem wada wadanti nipa hodoa na sa bre no omoye sa da government high ranking officials yabubo mudia sikeko mobia biewra makna oye abia agent ya assign no wo di case ya chi intercept emails ni nyina obia di metodwa obia members of parliament ya omo agi sa dem di ensure say sa take giant ye nya sa contract ye be no nyina ebio Government officials are no more yet power ministry. Yeah, sa asem yi kura no lead to the resignation of power minister. Yewra don kono. Omo nyina di be pepe. Nti it is an interesting case. Yeah, yeni edi akiri America abrochime.